the appeal is admitted, other side has appeared. Who is the other side? Call him. Call him and come at 12:30.
Of the supplementation in the final dispute. Today they have my
Serial number 5, right? The case is ready for final discussion. Parties have appeared. Case is ready. The case will be taken up and we will hear it on minutes. If the case is taken up, we will hear it on minutes.
From the supplementary list and the heading for press filing, item 1, DA1365 of 2016.
पास फॉरवर्ड करते नहीं आएंगे तो डिस्कस करेंगे.
And heading for admission, item 2, DA12.06.8 of 2025.
Petition allegation is under the Arms Act. The petition is not named in that here. The allegation is that two persons spiked ball, they came near the Panchayat hall and fired 2 shots.
We have 10 cases against
10 cases. In the case in which, in most of the cases, he has been granted bail, and in all of the cases, he has not been named in the FIR. He has been either it has come through the conditional statement, or his name has transpired in disclosure. One order of bail I would like to. The ATS case in which he was in custody at the time of occurrence of this FIR.
criminal activities and you
In
are
addition, only one request. As per my information, he was already in custody at the time of occurrence.
I do not know. From where do you say this?
Even in the ATS case from which he was remanded, he was in custody since then.
Here. BA number 12068 of 2025.
In addition, he has been in custody from before this. Only a report can be called for whether he was in custody in any.
Where are you saying? Do you say that he was in custody, in judicial custody on the date of occurrence?
At least till the.
I just want to know, do you say that on the date of occurrence he was in judicial
That
custody?
is the information that I have been
From
given.
where are you saying this?
Milord, I do
Is
not
it
have the
mentioned in
record.
your petition?
Milord, what I am saying is, he has been implicated in more than 10 cases. In some bail, it is given 12 cases. In some, it is given 10 cases. Only a report
If
will
you
be.
have stated it in your petition, then only I will call for a report. Otherwise, I will not. Show me where have you stated that on the date of occurrence you were in judicial custody.
No, I have.
DA number 12068 of 2025. For the learned counsel secretary on behalf of the parties. The learned counsel for the petition has submitted that the petition has been falsely implicated in this case and no incriminating articles have been recovered from the possession of the petitioner and the petition is in custody since 4/9/2024. The learned counsel for the state has opposed the prayer and has submitted that the petition is alleged to be working for Aman Sahu Gang since 2019 and as many as 10 criminal cases are of similar nature are pending against the petitioner. And the petitioner is alleged to have threatened and out of fear ransom amount is paid. After hearing the legal counsel for the parties and considering the fact that the petitioner has as many as 10 criminal antecedents, the state is not inclined to enlarge the petition on legal consideration.
There should only one correction. In another ATS case from which he was remanded, it has been recorded that he was in custody since 34/2024. Only that we.
We will not record it. Whatever is not mentioned,
It's
Sorry?
in order of that.
We will not, things which are not brought on record, we can't just record it like that. Call
I-
for the next.
Item 3, BA1 for 5 of 1926.
Pass over.
Item 4, BA191 of 2026.
Yeah. The main section is same before the besides the other sections. In the FIR note, there are only accused persons named, whereas 25 to 30 unknown persons have been mentioned. There is no specific overlap so far as unknown persons are concerned. The persons who are involved in the assault, their name has been spelled out by the informant. Subsequently, what he has been arrested, remanded from some other cases, but he was not put on trial. But the only eyewitness is the informant. None else. It was in the night, no one has seen except he informed. He himself says कि अपने को छुपा लिया था और देख रहे थे कौन मारा. But he has not given the name. And not he in this is 26th of July 2024. Nothing implementing article
2024. 20?
24. 26/7/24. ये correct होगा तो पहचान कर लेता है informant. He is the only eyewitness who has seen the offence.
He might not be knowing you.
He might.
He might not be knowing the entire crowd. A person may not know the entire crowd, isn't it?
That's true, but when he is arrested, but you have been put on trial.
How many cases do you have against?
I have not been arrested, I have 4 cases.
Of similar nature?
Not similar.
Yes, of course. Yes.
In one case, he has been granted bail by this court, this honorable court. In other, diary has been called for. So far as the 2 cases are concerned.
All are of similar nature. All underground sacks, CLA, 387, 307. Really, because 302 is not there, that doesn't mean that it is not a similar.
I don't know very well how the antecedents are being made.
No, I do not know.
So far as this
I don't
case,
have any personal knowledge about how the antecedents are made.
so far as this case is concerned, there is no such
You
event.
see, in these serious kind of cases, you have to bear it for some time.
They not
I will expedite that trial, there is no problem. Investigation is over.
charge has been framed.
Charge has been framed.
Yeah, that is apparent from the order sheet.
We'll expedite it.
But some time may kindly be given.
We'll do that. We'll
Yeah.
do
Okay,
that.
okay.
When was the charge framed?
But from the order sheet itself, it is mentioned. Page 3 of the order sheet, the report further reveals that charge has been framed and the case is pending at the stage of prosecution. Notice order is of 11 July 2025.
We produce our witnesses. Charge has been framed. You ensure production of witnesses.
July 25 charge was.
Yes. For the learned counsel secretary on behalf of the parties, the learned counsel for the petitioner submits that the petitioner is in custody since 26/7/2024, and in the FIR, some of the persons who were part of the crowd have been mentioned, but the name of the petitioner does not appear. He has also submitted that the petitioner has been falsely implicated in this case and no specific overt act has been committed by this petitioner. The learned counsel for the state has opposed the prayer and has submitted that the case is of commission of double murder of the brother and father of the informant, and the same was on account of demand of levy made by the members of extremist organization named and styled as TSPC. He submits that there are as many as 4 criminal antecedents. 4 criminal antecedents against the petitioner of serious nature. To this, the counsel for the petitioner has submitted that the charge has already been framed as recorded in the input order dated 11/7/2025, and the trial be expedited. Time frame to देना मुश्किल है, but we'll ensure that it is done. After hearing the learned counsel for the parties, to this, the counsel for the state has submitted that the state will ensure prompt production of witnesses. After hearing the learned counsel for the parties and considering the serious nature of allegation and also the criminal antecedents of the petitioner, this court is not inclined to enlarge the petitioner on bail. The state is directed to ensure prompt production of witnesses before the court. The counsel for the state is directed to communicate this order to the Director of Prosecution and also the Superintendent of Police of the concerned district to ensure compliance. That should be sufficient. टाइम फ्रेम हम कह सकते हैं, थोड़ा सा मुश्किल है। अगर इस बीच भी अगर विटनेसेस नहीं आते हैं तो हम आगे मिल सकते हैं। ऐसा नहीं है। They have been asked to produce witnesses. You said ensure production of witnesses.
From daily list, under heading for press filing, item 4, DA 1648 of 2026.
Pass over.
Item 5, DA 1651 of 2026.
Who is for the petitioner? Pass over. Next. You are there in that case. Pass over.
Yes.
The informant's daughter was taken away by this petitioner at Malcolm's Allegation in the FIR. Subsequently, they were recovered from Bengal, and he is in custody from 28/11/25. Age of the victim members, as per the prosecution case, they say she is a minor, but the doctor's medical examination has stated para-11.
Education certificate is.
That is there, but the doctor examine says she is 17. The diary also, and then
17 से भी कुछ नहीं होगा ना?
and in 96 was violation of a minor for the purpose of sexual intercourse. That has not happened as stated.
Forcibly done, as per the allegation.
Well, that is not been. That is what I am saying, because it has come in a statement before the magistrate, which is part of the diary.
No, it is 180. Is it wrongly recorded? Forcibly kidnapped. A statement has been recorded in the diary. Is it wrongly recorded in the order?
Before the magistrate, she has not stated. I have stated in my petition also.
Her statement has been recorded.
Yes. I was only the use for a moment to paragraph number.
Nikhil, call for the case diary along with the statement of the victim recorded under section 183 BNS. Correct?
Paragraph 10 I have stated. Therefore,
Never physically exploited is not sufficient. Forcibly. That is the crux.
never forcibly we don't rely.
Physically exploited, let's see what's her statement. If she has not supported, we'll see.
Right.
Counsel for the state is absent. The state is also directed to file a counter affidavit in this case. Close this case on 7th of April. Since the state is absent, office is directed to forward a soft copy of this order to the Office of Learned Advocate General to ensure compliance.
Item 6, DA 1659 of 2026. Item 7, DA 1667 of 2026.
The accused is booked under NDPS Act.
30 pages.
NDPS Act, our PS case number is 2020.
30 pages.
Your Ladyship, the accused is under custody since 4 years now. Since 6/3/2022, the co-accused Sonopal has been granted bail and in PA number 10045 of 2025, order dated 20/11/25. There has been no progress in the trial also.
It is the order of the court.
It should be.
It appears that 7 prosecution witnesses have been examined. It is mentioned in the order itself. And only 2 witnesses are yet to be examined.
Your Ladyship, 2 independent witnesses which are posted to this case. The notice has been given to the senior SP also.
Okay. DA number 1667 of 2026. Order and consulate hearing on behalf of the petitioner. Nobody appears on behalf of the state. The counsel for the petitioner submits that the petitioner is in custody since
6/3/2020.
6/3/2022 and there is no progress in the trial, and the co-accused namely Sonu Pal has been granted bail by this court by the order dated by coordinate bench of this court by the order dated 21/11/2025. From the perusal of the order of the co-accused, this court finds that 7 prosecution witnesses, it has been recorded in the order itself that 7 prosecution witnesses were examined and 2 witnesses relating to Caesar list were yet to be examined. During the course of hearing, the counsel for the petitioner has now pointed out to this court that his bail application was rejected earlier by coordinate bench of this court in DA number 7351 of 2022. There is huge recovery of 30 kg of cannabis from the possession of the petitioner. In view of the aforesaid facts and circumstances, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure production of the remaining witnesses to ensure that so that the trial is concluded at the earliest. Counsel for the state is directed to communicate this order to the Director of Prosecution and also to the concerned SP to the SP of the concerned district to ensure compliance. Rejected. आपके appearance record करें. Mr. Pankaj Kumar appears on behalf of the state to oppose the prayer. Why didn't you point out that your bail has been rejected earlier?
2 ways has been rejected earlier.
Why didn't you point out?
I was about to point out.
I gave you very patient hearing. You never said so.
Your ladyship, I was there. I was about to point out that
This speaks volumes, right? Rejected twice earlier, Nikhil.
about to point out.
I gave you sufficient opportunity. You can't say that. Once in BA number 7351 of 2022 by order dated 22nd July 2022, and then in BA number 9 of 2023 by order dated 27th September 2023. This is arising out of the same case or it is arising out of a different
No,
case?
same case.
Item 8, DA 1675 of 2026.
So the allegations that the informant and petitioner were neighbors, and the informant came back from somewhere, the petitioner parked his bike in front of his car, and there was a quarrel between them. During which the informant was tracked and assaulted. The petitioner is in custody since November. This month, between an incident of 498, during the trial, the parties also entered into a compromise. Certified copy of the compromise petition has also been brought on record as election fee.
Is it a compoundable offense? There is a transaction of money also. There is a transaction of money also. Settled amount has been paid.
Yes.
Is it a compoundable offense?
But there are judgments now in the Supreme Court that
This is not a washing application. BA number
but he's in
1675.
custody matters for more than 3 months now. Except section 307 ordinance.
Your anticipatory bail was rejected.
Yes, ma'am.
Then ultimately,
I was directed to
but
sign.
you did not.
I filed that. I did not because after that the parties entered into a compromise, so I preferred a fresh maybe.
Compromise is not a ground one.
But I am in custody matters, investigation is also complete, so no useful purpose will be served by you. I'm in custody for more than 3 months now. And the charge sheet has been filed, so investigation is complete and no useful
We
purpose will be
expedite
served.
it. You are in a position to influence the witnesses also. BA number 1675 of 2026. For the learned counsels appearing on behalf of the parties, the counsel for the petitioner has submitted that the petitioner is in custody since 9/11/2025. And earlier, the anticipatory bail application of the petitioner was rejected. In ABA number 7880 of 2022. The learned counsel has also submitted that parties have entered into compromise. And the settled amount has been deleted. Counsel for the state has opposed the claim and has submitted that the offence is not compoundable. And there is direct allegation against the petitioner. After hearing the learned counsel for the parties and considering the direct allegation against the petitioner, this court is not inclined to enlarge the petition on bail. However, the state is directed to ensure prompt production of witnesses. The counsel for the state is directed to communicate this order to the concerned SP and the director of the state.
Item 9, DA 1682 of 2026.
Counsel for the petition seeks permission to withdraw this application. Dismisses.
Sign कर दीजिए. Sign कर दीजिए.
You filed it just now. You filed it just now during the court proceedings. उनका वकालत क्या नाम है आपका?
शशांक
लेकर आइए,
लेकर के आइए फिर अच्छे उसमें साइन भी करना।
साइन करिए, वकालतनामा फाइल करिए इसमें।
Item 10, DA1686 of 2026.
इनका फोन नंबर नोट करिए। यस,
But there is allegation that this petitioner has taken an amount of 33 lakhs.
35 लाख, 15 क्रिमिनल एक्ट।
In some of the cases he has been granted, in some of the cases he has been granted.
In all the cases you have been granted?
Yes.
In all the cases?
अरे एक तो वो हम फाइट करेंगे
नहीं, फोन करने का जरूरत
काउंटर
नहीं।
काउंटर है
काफी है, सरकारी पैसा आप लेके जाइए।
सरकारी पैसा नहीं
सरकारी पैसा
ना ना एक बार देखा ये नवीन कंस्ट्रक्शन का पैसा है नवीन कंस्ट्रक्शन इज द प्राइवेट एंटिटी
चीफ से फोन नंबर को क्लोन करके ये
और
कोई बात नहीं,
जो-
नहीं, नॉट अ केस फॉर बेल, प्लीज डोंट।
इसमें जो एक बार केस डायरी बना लो
कोई जरूरत ही नहीं है।
तो आप डेमोक्रेट करते हैं
BA number 1686 of
the
2026. Heard the learned counsel
the
pleading
way
on
of
behalf.
transaction is suspicious.
That's right. Heard the learned counsel pleading on behalf of the petitioner. The learned counsel for the petitioner submits that the petitioner has been falsely implicated.
I believe
After some argument when this court was not inclined to enlarge the petition on bail, the counsel for the petitioner seeks permission to withdraw his application. Dismiss suspicion.
साइन कर दीजिए। Item 11, DA1689 of 2026.
Relation to the matter pertains to sections 376 and 313 facts. In addition, the present FIR in this case was filed on the basis of a contained case which was registered in 2024. And the allegations made there is that in 2016,
What is the age of the victim?
Russia sheer major, he was major.
Case diary. State to file contract with the victim. So it's a counsel for the state is absent. Office is directed to go and take a soft copy of this order. The office of learned advocate will ensure compliance.
क्रिमिनल एंटीसीडेंट भी सिर्फ
Criminal antecedent. Case diary counter.
डेट वही 7 है, अभी 19 केस जा चुका है।
7th के बाद वो 8 date.
Item 12, DA1691 of 2026.
Excise Act. And the 80 liter container and over liter has been seized from the forest here. And only on the basis of suspicion that this land has been implicated in this land here. And the other similarly subject to my two persons are already contracted by this honorable court by page number 27 Ajay and another vehicle has been granted anticipated page number 24. And petitioner is in custody since 6 January 2025.
Page number 20.
27 is bail number for insurance and 24 is
Page number 20 पे किसका वेट?
page number 20.
या आपको क्या है वेट ऑर्डर?
ये तो
अच्छा ये रिजेक्शन।
yes 24 is anticipated is 25 anticipated is and then 27 days
25 पर एंटीसिपेटरी पेड है,
27 days
18 पर भी एंटीसिपेटरी पेड है,
and 27 days
पेज नंबर
27 इंक्लूड वाला लिस्टिंग का केवल दो एंटीसीडेंट आए हैं नॉट जैसे एक मार्केट का और एक सिमिलर ऑफेंस का उसके अलावा स्पेस में ये का भी है वहां पे
You were apprehended on the spot.
No. Later, on the basis of suspicion, I did. And later on, I have been arrested.
You are in custody since 6/1/26. Charge sheet हो गया?
Yes. 6.
6/1/26.
Yes.
चार्ज शीट हो गया?
Just.
क्या बोल रहे हैं आपको? पकड़ाए हैं क्या? स्पॉट पे नहीं पकड़ाए हैं, रिकवरी भी नहीं है। पोजीशन से नहीं है, कहाँ से? जंगल से।
इधर लगा है this. Antecedent explain के prior to the
For the learned counsel appearing on behalf of the parties, the counsel for the petition submits that it is alleged that the petitioner is involved in manufacture of illicit mahua liquor and from the site 80 liters of illicit mahua liquor and 300 kg of Java mahua was recovered. The learned counsel submits that the recovery was from forest area and the petitioner was neither apprehended on the spot nor any recovery is there from the petitioner. He has submitted that the petitioner has 2 criminal antecedents, but only one is relating to similar offence. He has also submitted that who accused Lady Ajay Yadav has been enlarged on bail by appointed bench of this court in BA number 4255 of 2025, dated 15th of May 2025, who also had a criminal antecedent. He has further submitted that the charge sheet has already been submitted in this case. The counsel for the state is supposed to aware and has submitted that the petitioner has criminal antecedent and therefore he may not be enlarged on bail. However, he does not dispute that neither the petitioner was arrested on the spot nor there is any recovery from the possession of the petitioner. After hearing the learned counsel for the parties and considering the aforesaid submissions, and also the fact that a similarly situated co-accused has been granted bail, as mentioned above, and charge sheet has been submitted, the petition is expected to be enlarged on bail.
Item 13, BA 1696 of 2026.
Counted affidavit, case diary, criminal antecedent. 8th of April. Since the counsel for the state is absent, officers are ready to communicate a soft copy of this order with the Office of Learned Advocate General for issue compliance. 8th of April.
Item 14, BA 1712 of 2026.
Case is of using criminal force while committing theft. The informant was robbed of 45,000 rupees.
सेम ऑर्डर करेंगे एक काउंटर फाइल करेंगे इसमें कॉम्प्लिकेशन नहीं होगा काउंटर पर दस नहीं काउंटर फाइल करिए सीधी का कैश कोड का होगा आपका कॉल फॉर सीधी फ्रॉम द कंसर्न क्रिमिनल एंटिसिपेट
Case of 4 people not dying.
अच्छा देखिए चाहिए The learned counsel for the petitioner has submitted that in the case of co-accused, case diary has been called for. इसका डेट क्या है? देखिए तो ये case diary and criminal antecedent report has been called for. अब इसको कैसे हम लोग करें? मुश्किल है। अब ये किसके बेंच में जाएगा? मुश्किल है। बस जो ऑर्डर किए हैं वही रहेगा है ना आप काउंटर फाइल कर दीजिए ऐसे 8
स्टेटस रिपोर्ट मिलेगा।
स्टेटस
Item 15-1718 of 2026.
In the office, initially the fire has been lodged under section 1031 and 35 of the DNS 302/2026. And later on the charge sheet has been submitted and cognizance has been taken for the offence under section 80, subsection 2 and 35 of the DNS. 80, subsection 2/2026 of the DNS. As per the allegation of this, the decision has consumed by
Where is the husband?
Husband and this laws, Bhaishur, they were not present in the court.
Where is the husband?
Husband jail,
कहाँ?
उसका भी time
बताइए.
बता. एक इसमें गोतनी का था, उसको एक use कर दिया. इसमें 3 स्टोरी है लड़के. पहला जहाँ डेथ किए हैं वहाँ पे इसके डिसीज के नाना जी बोलते हैं कि आ रहे थे फिर सदर हॉस्पिटल हजारीबाग में वहाँ हम इन लोग को डिस्ट्रिक्ट मॉडल में मिले. फिर वहाँ से इन लोग जो इन-लॉज जो गोतनी थी एक और एक जो विलेजर था वो लेके इन लोग को यहाँ आया आर्टिस्ट हॉस्पिटल रांची में. वहाँ एडमिट किया. वहाँ पर या तो पुलिस स्टेशन के सामने कहीं लोग नहीं मिला कि कभी कोई मिला है मर्डर से प्रायर टू हर डेथ. एंड
She died in a very short time from the marriage.
हाँ बस दैट इज वो एक्चुअली वो क्या हुआ लव लेडीज की शादी के टाइम एक डिस्प्यूट हुआ था कि जो हस्बैंड है उसके साथ बाराती लोग गया तो मारपीट हो गया था. तो ये बोला था कि नया कार्ड से निकलना मिलाना है. दैट इज ओनली रीजन शी कमिटेड सुसाइड. और जो इसके साथ इंडिपेंडेंट विटनेस जो विलेजर है वो लेके इसको गया था हॉस्पिटल जाने के क्रम में किसी जब जहर पी ली तो बोली कि हम गुस्सा में भैया खा लिए जहर तो हमको बचा लीजिए. तो वो और एक उसकी बड़ी होती मंजू देवी.
नहीं, she has given dying declaration also.
नहीं यही तो बताया मैंने कि ये जो
Case diary चाहिए. Call for case diary. The state to file contract. 8th of April. हस्बैंड का बेल नंबर बताइए. हमको लग रहा है हस्बैंड भागा हुआ है इसलिए पूछ रहे हैं. 18
जेल में हम फाइल किए.
Item 16, DA1722 of 2026.
इसमें डाइंग डिक्लेरेशन है ना स्टेट. तो डाइंग डिक्लेरेशन है ना. केस डायरी में तो होगा. आप काउंटर एफिडेविट में उसको स्पेसिफिकली देखिए. एपरेंटली डाइंग डिक्लेरेशन. यस.
Under question is two named accusers. Very interview alleged that he was talking terms with the informant for about 2 to 3 months with Rahul Kumar Patel. Subsequently, one day they reached the house of the.
He was apprehended.
But this is the case. In fact, what has happened in this case that both the girl and boy were there. And when the passing two persons have seen them.
Not the case for bail. देख लेना बहुत सीरियस है सिचुएशन.
लेकिन एलिगेशन रीड करनी है. एक बार यूरोलॉजिक देखेंगी तो only the allegation is that the
DA number 1722 of 2026.
मतलब एक चीज जो submission process. मतलब the informant along with the petitioner, both in the vehicle, motorcycle, they traveled from the house of the informant towards the jungle. And their minority petitioner has been found with the girl. So minority, they were talking to her. It has already been mentioned in the FIR. She has admitted this fact. So and minority, there is no document annexed with the FIR which will go to suggest that the victim was minor or lesser. If the age is 18 years, which minority Supreme Court in case of Jamala versus the state of Jammu and Kashmir, old minority that if there is finding only on the basis of radiological finding. Then there is error of 2 years. There will be error of 2 years in either side. Subsequently,
14 साल की फीस
वही वही
प्लस माइनस
नहीं वही कह रहे हैं
डेट ऑफ बर्थ इज मेंशन अब इनका काम है बोलने का
Date of birth is mentioned, but no document has been submitted. Allowed in the case of Phillips.
जस्ट अ मोमेंट
In the case
वॉशिंग बहस कर रहे हैं ये नंबर 177 वॉशिंग बहस करिएगा तो ये सब कहानी सुनिएगा ये नंबर 177 of 2026 for the learned counsel is appealing on behalf of the parties. The learned counsel for the petitioner submits that that as per the prosecution case, the petitioner was in talking terms with the accused and
petitioner के साथ नहीं था, another के साथ पटेल सलीम उसका बाद में सलीम नाम आया।
अच्छा
और petitioner है वो इनके साथ में थे।
petitioner the victim was in talking terms with the co-accused.
Rahul Patel alias Salim.
Yes.
Salim.
Yes, he has submitted that the victim had moved in motorcycle along with both the co-accused and subsequently they were apprehended by the villagers. He has submitted that there is no material to show that the victim was a minor girl. The learned counsel for the state has opposed the prayer and has submitted that the victim has supported the prosecution case and though she was taken in motorcycle, but when she raised alarm, she was threatened and ultimately the two boys took her to Ulda jungle and started molesting her by touching her body parts. In further, the villagers apprehended both the co-accused, both the accused, and on interrogation, the boy named Rahul Kumar disclosed his actual name as Mohammed Salim, and another boy disclosed his name as Soeb Ansari. The victim further alleged that Salim, by hiding his actual Muslim name and by keeping a Hindu name, talked to her in deceitful manner. He has submitted that the date of birth of the victim has been collected, which has been found to be 1/1/2009. After hearing the learned counsel for the parties and considering the serious nature of allegation, and that the petitioner was apprehended on the spot along with co-accused, this court is not inclined to enlarge the petition on bail.
Item 17, DA.17.04 of 2026.
FIR against unknown. Case diary
I
company.
have received the hearing and I communicated this on behalf of the discussion, but beyond confession of the petitioner it had been disclosed there was a illicit relation with the deceased and the wife of the petitioner and therefore the offence has been taken place and the petitioner confessed that he has committed murder.
The counsel, the counsel for the parties are present. The counsel for the state has submitted the case diary to this court. Post this case to us. जो आपको मार्क करना है करके दे दीजिए ना, उसको फोल्ड करके दीजिए, उनको केस डायरी वापस करिए, आप उसको फोल्ड करके दीजिए, you can pencil लीजिए उनको मार्क चलिए नेक्स्ट
Item 18 DA1743/2026.
Yes, petitioner.
This is 696 of BNS. The statement of the victim has also been recorded under section 183C BNS prior arrest that is at page 70. Informant alleges that this petitioner has enticed away from his minor. Her statement has recorded also annexure 3. Page 7, starts from page 17. Last line.
Please read it. क्या आप अपने बयान में यस
मैंने बात कर साबित की क्योंकि माँ पापा नहीं मान रहे थे, हमारे बीच कुछ नहीं हुआ है। सोनू मेरा पति है, वो हमको आज तक सिर्फ मेरा हाथ पकड़ा है। हम अपने से और अपनी मर्जी से भागे थे, तो सोनू बहुत अच्छा लगता है।
victim का एज क्या
15 years of आपको सर्टिफिकेट 15 years जो 183 के स्टेटमेंट है उसमें भी 15 years
26/10/2010 लेकिन आया
उस स्टेटमेंट हम इसकी उसमें भी बहुत क्लियर किया अरे कुछ स्पेसिफिकली बोले कि सिर्फ आप पकड़ो से
मेडिकल एग्जामिनेशन हुआ है डैडी है डैडी में इनका मेडिकल एग्जामिनेशन है वही नहीं है डैडी कब से आप कस्टडी में
3/11/25
एंटीसीडेंट 379 इससे तो कोई लेना देना नहीं
इसी को पर इसी बस है इधर ना बात बस यही वो लास्ट में उसका डेट ऑफ बर्थ का सर्टिफिकेट लगा हुआ है स्कूल का 2010 का डेट ऑफ बर्थ
इन हाई स्कूल के बारे में
और the learned counsels appearing on behalf of the party. Statute for ही क्या होगा? The learned counsel for the petitioner submits that the statement of the victim has been recorded under section 183 BNSS and she has submitted that she eloped with the petitioner and performed marriage and no sexual act has been committed by the petitioner. He submits that the petitioner is aged 23 years and he is in custody since 3/11/2025. Charge sheet has already been submitted. Counsel for the state has submitted that the victim was kidnapped and is a minor. And she was recovered from West Burdwan, West Bengal, from the house of relative of the petitioner. During the course of hearing, it transpired that in paragraph 49 of the case diary, it has been recorded that the victim was produced for medical examination, but the relatives of the petitioner refused for medical examination. Take the details.
Victim के relative, sir.
Victim के लिए, petitioner ने victim, sorry, petitioner ने victim, sorry, victim के relatives, they refused for medical examination. To this, the counsel for the petitioner has submitted that the victim in a statement has not supported the case of any enticement or kidnapping. After hearing the learned counsel for the parties and after considering the aforesaid submissions and that the charge sheet having already been submitted, the petition is directed to be enlightened.
Item 19, DA1749 of 2026.
These sections are 331 and 305. This relates to the theft in dwelling house and house trespass. I was explaining the unknown person. And that page 18.
Any recovery from your possession?
The name of the petition only taken into investigation that the stolen product ornaments was sold to one jewelry shop and that jewelry shop had transferred 50,000 rupees in account of the petition. And my justification to not suffer. The petitioner used to be owner of the one motorcycle showroom. One co-accused person who has shared the ornaments to the jewelry shop that would be
Case diary transfer criminal antecedent. Eight of it.
This already within the punishment of 7 years. His custody is
So back to case diary देखनी पड़ेगी. Criminal antecedent, case diary, and contract. 8th of April.
Item 20, DA1751 of 2026.
Case diary, contract, criminal antecedent. 8th.
Yes.
You file your contract.
Yes, sir.
Charge sheet must have been submitted by now. Case diary from the court.
Item 21, DA1761 of 2026.
The basis of secret information, raid was conducted in the house of the petitioner. Thereafter, there is a recovery of mobile statement cards in the house of the petitioner. Custody. Since 13 to 25, he has been in accident.
Same one. Case diary, criminal antecedent, report, and contract. So it's a counsel for the. Are you there?
Yes.
ये दोनों same case से है क्या? अलग case है. Same one. 8th April.
Item 22, DA1777 of 2026.
lost the first information on the basis that the deceased
Are you
along
named in the FIR?
FRT was submitted, meaning thereby that the case was not found to be true as against this petitioner. Subsequently, he filed a complaint case. On the basis of a complaint case, cognizance has been taken. 5 persons, cognizance has been taken against 5 persons. 3 of them have already been granted bail. And the case of this petitioner stands on a much better footing to that of the persons who have been granted bail.
In 302 FRT was
Yes, because the deceased and his accomplices, they had gone to the house of one Vijay Mathur to assassinate him. And thereafter on shout, the entire village people came and assaulted him in such a manner that he got killed. After his being done to death, then a false case was registered against unknown. Subsequent to that, the police on inquiry has submitted the final report, which is at page 31, annexed 2 by 1. And even in the complaint case, there is no specific allegation as against the present petition. Firstly, the FIR was registered, then a final report was submitted, thereafter a complaint
It is
case.
arising out of a complaint case.
Complaint case.
We'll issue notice to the OP.
That is annexed 1.
We'll issue because state will issue notice to the OP number 2. State will not be in a position to say anything.
The other 3 persons have already been.
We will issue notice to the OP number. Here you there. The state will have nothing to say. BA number 1777 of 2026. The case arises out of a complaint case. Issue notice to the opposite party number 2 for which requisites and as a close be filed by Monday.
We have not made
He is a party. He is a party. You have made him party.
Today we are going to submit the
During the course of the year. Office to track speed post delivery was this case on 8th of April.
Item 23, 1780/2026.
Officer section 109 of the and 17 of this Mediation. Several copies have been granted there is allegation that past share unknown person I or truck के टायर पे गोली मारी and they asked for the legal version. Several copies have been granted where I have annexed the order as annexed to page 19 version.
Counter affidavit. Case study counter affidavit criminal anticipation.
Appearance is Item 24, BA 1781 of 2026.
There was called in BA number 126 in 2026, arising out of same case.
1268.
2026.
Who has called for this case? Is it my order? Case ID criminal antecedent report counter. 8 April.
This is being checked on the
We can't tag it, we do not know to which bench it is assigned.
this one.
Cover date
10/3/2026.
10/3.
On that day, order was passed, and the case is next date on 2/4/20.
Move 4
Yes,
2nd April को कर दीजिए, काउंटर फाइल कर दीजिए। Yes, ऐसा लिखिए। I have passed this order.
your words.
Counsel for the petitioner submits that the case ID has been called for by this court in the case of co-accused in BA number 1268 of 2026, and the next date fixed in the matter is 2nd of April. Counsel for the state is directed to file a counter affidavit along with criminal antecedent report of the petitioner. Pose this case on 2nd of April to be taken up along with BA number 1268 of 2026.
On the heading for admission, item 25, DA 111644/2025.
Allegation and decision to be brought to file cases named in FIR, no specific allegation against this petitioner. No recovery. Custody says 21/11/2022. 3 year and 3 months. Charge has been filed on 21/9/2023. And in 2 years, also only 1 witness has been examined out of 10 witnesses. Other co-accused process.
Just a moment. From where do I get how many witnesses have been examined?
Now, let me know. Page number 21. Last second line. It is further submitted that charge has been filed against the petitioner on 21/9/2023. Until date, only a single witness has been examined on behalf of the prosecution. And petitioner is mentioned since 21/11/2022. Period of custody 3 year and 3 months, more than 3 year and 3 months.
We'll expedite your trial. You have number of criminal antecedents. I heard the legal counsel appearing on behalf of the petitioner. The learned counsel submits that the petitioner is in custody since 21/11/2022, and as per the improved order dated 1/11/2025, out of 10 charge sheeted witnesses, only 1 witness was examined, although the charge was framed on 21/9/2023. He has submitted that one co-accused, Ratan Turi, has been enlarged on bail in BA number 7438 of 2023. After hearing the learned counsel for the petitioner, this court finds that there is serious allegation against the petitioner, and the petitioner also has criminal antecedents. Total number 15 as mentioned in the agreement. In such circumstances, the case of the petitioner is different from the case of co-accused, who was said to have no criminal antecedent. Considering the seriousness of offence, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure prompt production of witnesses. Counsel for the state is directed to communicate this order to the Director of Prosecution and also to the SP of the concerned district to ensure compliance.
Time frame.
Time frame is
Item 26, BA 11783 of 2025.
Until the 140 years
according to 364A of the Allegation. Allegation is that the petitioner along with another witness kidnapped a informer for ransom. However, the reason why not named in the FIR have been transparent in the case only on the basis of convincing statement of the accused. There is no recovery from it. In this case, it is situation, whoever has been
Case diary, criminal antecedent report, counter. 8th of April. So,
Item 27, DA 90 of 2026.
FIR was registered against the unknown person. Subsequently, during the course of investigation, several accused persons were arrested, charge sheet was submitted. One other case was registered, which is not related to this case. In that case, the accused persons have confessed the name of this petitioner in the instant case. Only on that basis, his name was transferred in this case. And similarly situated other accused persons have already been granted waivers. I have annexed the copy on annexure 2 series. Starts from page 7.
then file a counter. His voluminous counter, this will file a counter after.
I will not have I will get it.
Counsel for the state is directed to file a counter affidavit in this case. 8th of April. Case diary has already been received. And also criminal antecedent report.
Item 28, DA 460 of 2026.
The final instituted under section 69 of Bharatiya Nyaya Samhita, informant alleged that she is aged about 21 years 8 months and she was in relationship with this petitioner since January 2023. I, sometime in the day of Karma Puja, established physical relationship with her on pretext of marriage. Thereafter, we started loving each other and we visited Goa for some time. And we stayed in Goa for near about 17 days. And on the request of the parents, we came back. Thereafter, my lord, she conceived, but the pregnancy was aborted. Later on, my lord, the FIR was stated. This boy also believed the sunlight marriage to the girl, but when she was married to someone else prior to entering into this relationship, and when this petitioner requested her to seek divorce through operation of law, then my lord, the present case has been instituted. And the boy was never intended to relationship with any dishonest intention, he always intended to marry. But as she was married to someone prior
What is
to
the age of the victim?
21 years, 7 months. That is there in the FIR itself, in page number 31. Date of birth 25 2000. Father of the girl has been examined. He says, अभियुक्त विदेश मंत्रों ने मेरी बेटी के साथ कोई अपराध कारित नहीं किया. Page number 90. And this petitioner voluntarily surrendered before the government trial court. And when she was married, she has not disclosed this fact to the petitioner also.
She is a married lady.
It was not from his name also.
From where do you say that she was a married lady?
You kindly look page number 17.
17. Minus.
प्रमाणित किया जाता है कि सचिन सर का विवाह सचिन सर के साथ 29/10/2022 को परिवार के एवं स्थिति में राम मंदिर ईसाई धर्म हिंदू धर्म की स्थिति और जो डेट ऑफ मैरिज 29/10/22 का है.
केस डायरी में है ये डॉक्यूमेंट?
होना चाहिए आई नॉट सीन.
तो केस डायरी में जो डॉक्यूमेंट नहीं है तो आप ये यहाँ पे ये डॉक्यूमेंट हम क्या देखें? केस डायरी देखेंगे ना?
फादर से इसकी कोई ये नहीं किया है.
But you went to Goa, right? Voluntarily.
हम दोनों शादी कर लिए कोई फोर्स कुछ नहीं मेजर दर्द है लॉन्ग रिलेशनशिप था 2023 से 25 तक
क्या बोलना है बात? She has herself gone. केस डायरी करके भी क्या करना? She has herself gone. She went to Goa. ये पेज नंबर 18 में section 3 is the evidence of her father who has turned hostile.
But victim will not be examined.
ये और लोग मालूम नहीं दरकार हो रहा था कि डायग्नोस ले लो शादी का ये हम नहीं बोला है भारत का मेरी पीड़िता बेटी और दिनेश में तो इसमें शादी करने की बातचीत हुई है तथा दोनों शादी करना चाहते हैं
पहले से शादी है वो नहीं हो रहा ये बस पहले से शादीशुदा है ये नहीं हो रहा वो लोग दोनों शादी करना चाहते हैं
After counsel for the petition submits that the victim is a major who was having affair with the petitioner and they had also gone to Goa and spent some time there. It is alleged that in the pretext of marriage, the petitioner committed rape upon victim. The learned counsel has submitted that the petitioner is in custody since
19/9/2025
19/9/2025. Charge sheet has been submitted.
Yes.
Charge sheet has been submitted, and even the father of the petitioner has been declared hostile. Sorry, the father of the victim has been declared hostile. And during cross-examination, he has stated that there is talk of marriage going on between the parties. The learned counsel has also submitted that the petitioner has come to know that victim is a married lady. Counsel for the state has opposed the plea and has submitted that the petitioner has committed rape in the pretext of marriage. After hearing the learned counsel for the parties and considering the regard being had to the appropriate submission and the custody of the petitioner since 19/9/2025, and he has already been, and the charge sheet having already been submitted, the petitioner is directed to be adjourned.
Item 29, DA 589 of 2026.
Yeah. First, kindly remember the last order, that is 29/27.
Next week. Is it a compoundable offense? Okay.
when the compromise arises, not
कॉम्प्रोमाइज होता है तो एक्विटल कराइए ना. कंपाउंडेबल नहीं है ना, कॉम्प्रोमाइज के बेसिस पर आप
कंपाउंडेबल नहीं रहने के बाद भी बहुत सारे जजमेंट इस वक्त वगैरह है कि
वॉशिंग फाइल करिए.
स्पेसिंग
तो आप वॉशिंग फाइल करिए, बेल नहीं हो सकता. You see, while in jail, when you are in a position to influence to such an extent, what is the allegation? तो कंपाउंडेबल, कॉम्प्रोमाइज हो जाएगा.
कंपाउंडेबल तो नहीं,
डायरेक्ट एलिगेशन अगेंस्ट. ये सब यहाँ नहीं चाहिए. कॉम्प्रोमाइज हो गया, कहानी ले ली. एफआईआर पर रीड दैट.
वगैरह एक इशू है. After 2 and 3 lines,
एज कितना है विक्टिम का?
the neither 26 married age 26 प्रति स्टूडेंट को इनाम 3,25 इतना बजे फुटबॉल मैच का कुछ रुपया बचा हुआ है. उसी रुपया से ग्राम प्रधान के घर में खाना पीना का प्रबंध किया गया था. इस कारण आएंगे बोलकर निकल गए. तो समय करीब 7:30 बजे खाना खाकर न सो गए, लेकिन करीब 9:24 बजे रात में लाइन बंद कर दिए. जैसे ही मैं लाइन बंद की मेरे तो किसी ने कहा कि
और the learning council appearing on behalf of the parties. Also, for the petitioner submits that there has been compromise in this case. And the victim is a married lady. However, considering the seriousness of offence, which is of non-compoundable nature, and the petitioner is named accused in the FIR, this court is not inclined to enlarge the petitioner on bail. Rejected.
Item 30, BA 712/2026.
this case the final has been lost under everything. The secret information, two persons were apprehended by the police and from the position of the petitioner, 11.801 kg of ganja has been recovered, which comes under the intermediary quantity and the commercial quantity is 20 kg. There also the seizure list which was prepared by the police official is totally in violation of section 103 of BNSS, because there is no any independent witness who has put his signature in the seizure. And I am in the custody since 23/5/2024 and charge has been already paid.
Custody since
23/5/2025.
Earlier the bail of this petitioner was provided in Chavan, page 24. The two persons were apprehended and from their position were total 25.709 kg of
25.709.
But from my position,
that comes under the view of all commercial.
Joint possession,
Joint
है ना?
possession.
but from my position, 11.801 kg was recovered
And I have against
If you heard the learned counsel appearing on behalf of the parties,
The co-accused bail was again rejected, that is BA number, I will not get the order number, but it's BA number 11441 of 2025.
BA number
11441 of 2025, rejected on 19/12/2025.
heard the learned counsel appearing on behalf of the parties, the learned counsel for the petition has submitted that from the possession of the petitioner only intermediate quantity of ganja was recovered, and the petitioner is in custody since 23/5/2025 and charge has already been framed. The learned counsel for the state has opposed the prayer and has submitted that two persons were found coming on a motorcycle with 4 to 5 bags.
not from the motorcycle, they were walking.
पेज तो प्रोसिक्यूशन का यही है ना,
Not
पेज 41 में they were intercepted and nabbed and on search,
But there is no motorcycle.
but that is the case of the prosecution. गलत लिख दिया है क्या कोर्ट ने?
In the FIR, it is clearly that उन दोनों व्यक्तियों का सब को लेकर से कुछ पूछताछ किया तो उन्होंने अपना नाम पता ट्रांसफर को बताया। There is no use of motorcycle. Page number 29 FIR.
The learned counsel for the state has submitted that two persons were apprehended with huge quantity of ganja and the bail application of the petitioner was rejected by this court in VA number 7688 of 2025. And the bail application of the co-accused has also been rejected by this court in VA number 11441 of 2025 by order dated 19/12/2025. After hearing the learned counsel for the parties and considering the fact that the bail application of the petition has been rejected earlier and $11.801 kg of ganja was recovered from the possession of the petitioner and 14.908 kg of ganja was recovered from the possession of the co-accused Dalu Kumar, and both the co-accused were moving together. This court is not inclined to enlarge the petition on bail. However, the counsel for the state is directed to ensure production of witnesses. This counsel for the state is directed to reject it. Then the next one.
Item 31 BA 771 of 2026.
Yes, Petitioner.
So there is a negation of demand of levy by 6 persons out of 10 murdered by an extra 2. One co-accused has been granted regular bail. Is 15 crimes.
Are you named in the FIR?
No.
Case diary, criminal antecedent report. Have antecedent report. A former file करिए. Counsel for the state is directed to file counter affidavit in this case and also produce the criminal antecedent report. The counsel has produced a case diary. Not like the counsel for the state has submitted that he has received a case diary and undertakes to submit a copy of the case diary to the court by tomorrow. By tomorrow आप कर दीजिए. Post on 8th of April. Counter file कर दीजिए. Antecedent report.
Item 32, DA 892 of 2026.
Petitioner absent. The counsel for the state files counter affidavit which is taken on record. Goes tomorrow. Serve कर दिए ना petitioner को?
Item 33, DA 905 of 2026.
IE number 2783 of 26 has been filed for early hearing of this case, but the petitioner is absent. IE allowed, post tomorrow. Counsel for the state is present. आपका काउंटर आ गया इसको कॉल करिए. आपने आइए फाइल किया अर्ली हियरिंग के लिए. कल के लिए पोस्ट करते हैं. आइए अलाउ कर. आपका एब्सेंस रिकॉर्डेड है.
Pass over case from supplementary list. Item 1, DA 1365 of 2026.
DA number 1365 of 2026. Nobody appears on behalf of the petitioner on account of, in spite of repeated calls. The case was called out at the first instance, then it was passed over. Still nobody is appearing on behalf of the petitioner. Counsel for the state is present. The case was has been repeatedly adjourned at the instance of the petitioner. No adjournment request has been circulated. Accordingly, this petition is dismissed for non-prosecution.
If for not today,
Appear not today.
Pass over case item 3, DA 145 of 2026.
Petition.
Also,
Yes, Yes, earlier, yesterday also it was adjourned. The matter was directed to be posted today. Sorry?
The listener is regularly threatening the victim. He has also made WhatsApp call, video call, and shown gun to the and say to withdraw the same. And we have also made this
PA number 145 of 2026. The case was listed yesterday, and at the request of the petitioner, the case has been listed today. This case has been called out earlier, and nobody had appeared. And upon passover also nobody is appearing on behalf of the petitioner. No adjournment request has been circulated in this case. This petition is dismissed from our prosecution. To the list.
Passover sketch from daily list. Item 5 BA 1651 of 2026.
That the alleged offences under section 3083, 3084, 3085, 61 of the DRS Law, Arms Act and 17 CA. The case of the prosecution that may I just submit this earlier twice rejected by court.
So what is the fresh ground?
Not fresh ground, not custody issues. At not if you also see not addition 1 by 1 page number 13, not there was rejected at that stage. Now the Lord has completed more than 1 year of custody. He is in custody since 12/1/2020.
13 cases against
13 cases not in all cases I have been granted bail, and not in some of the cases I have also been acquitted. Now not only one ultimate is the
we'll expedite that side.
Lord is a witness नहीं हुआ. Lord if you Lord
करा देते हैं ना?
if you also deem fit Lord
करा देते हैं।
मान लिया जाता है कि स्टेटस से टाइम
कोई जरूरत नहीं है, हम अभी इसको डायरेक्शन देते हैं। करेंगे ना प्रोड्यूस द विटनेसेस।
Earlier rejected on the basis of criminal state. He has criminal state.
We are not on that. Witness प्रोड्यूस करेंगे। बताइए।
But time required मान लिया जाता है. Date fixed है, but I am not sure the time or something like that. Only not.
Did you produce the witnesses? Did you produce? Yeah. What is the stage?
Not charge framed. Not जब review order pass हुआ है by that time not even single witness.
Charge frame.
हाँ charge.
Charge frame
हो
होता
जाए
तो
जिस तक कोई witness हिसाब नहीं हुआ.
you will expedite that to produce the witnesses. All the learned counsels appearing on behalf of the parties. The counsel for the petitioner has submitted that the bail application of the petitioner has been rejected twice earlier. In PA number 5482 of 2025 by order dated 23/9/2025, and thereafter in PA number 1168 of 2025 by order dated 5/12/2025. And the petitioner is in custody since 12/1/2025. They have submitted that the charge has already been framed, but not even single witness has been examined till the passing of the impugned order dated 29/1/2026. However, he is not aware as to whether thereafter any witness has been examined or not. The learned counsel for the state has opposed the prayer and has submitted that the petitioner has a number of criminal antecedents and the allegation is of serious nature, he may not be enlarged on bail. After hearing the learned counsel for the parties and considering the fact that the bail application of the petitioner has been rejected on merit Twice earlier, this court is not inclined to enlarge the petition on bail. However, the state is directed to promptly produce the witnesses before the court. The counsel for the state is directed to communicate this order to the director of prosecution and also to the superintendent of police of the concerned district.
Item 6, DA 1659 of 2026.
BA number 1659 of 2026. The counsel for the petition submits that unfortunately the petition has expired. And therefore he does not want to press this application. This application is dismissed as not pressed. He died in custody.
Because in old age, he was fit. In old age, he was taken to Sada hospital also.
From the supplementary list, under heading for Lok Adalat, item 10, second appeal 14 of 2017.
Yes. Are you ready for Lok Adalat?
Your Lordship, he's stating that there is a compromise between the petitioner and the appellant and the respondent. Your Lordship, how do we have no instructions regarding that? I hope you are even behalf of respondent to be in.
Where is the report that it has been settled? List of settled cases. This is SA 14. SA 14 of 2017. This was settled in Lok Adalat.
Your Lordship, this matter may be listed for tomorrow so that we can take instructions for the client because we do not have any instruction on that regard.
लोक अदालत में सेटल हो गया तो दोबारा क्या भेजे इसमें? यस कोर्ट मास्टर जब सेटल हो गया लोक अदालत में तो दोबारा किस लिए भेजे इसमें? There is a report that it has already been settled. List of settled cases. 27/11/2025 को. Mediation. National Lok Adalat schedule of 13/12/2025. Special media altogether 39 cases have not yet been disposed of. List of settled cases with powers. We have the Lok Adalat day after tomorrow. I am referring it for Lok Adalat. You instruct your client to be there. Okay? the consent of the counsel for the parties. So this matter is placed for the ensuing yoga valid. On Saturday, we have to.
Item 11, second appeal 262 of 2017.
Nobody is engaged on behalf of the parties. Accordingly, this matter cannot be referred for local ballot / mediation. Earlier also on 12/12/25, the counsel for the respondents on instructions had submitted that the respondents are not ready for mediation. Post this case under appropriate heading on 9th of April.
Item 12, second appeal 308 of 2018.
Are you ready for mediation? Lok Adalat.
Mediation already successful now.
So, भेज देते हैं परसों को. With the consent of the learned counsel for the parties, post this case for in the ensuing Lok Adalat. Saturday को.
Item 13, second appeal 334 of 2018.
Sorry. So, mediation was successful. With the consent of the learned counsel for the parties, post this case in ensuing Lok Adalat. No. Why? Mediation has been successful. And why not in Lok Adalat? Terms of settlement? Yes. Who is your senior? He has told you should not go to Lok Adalat. यहीं पे कोर्ट में बात करना आप उनसे. Poor persons. Lok Adalat is meant for poor persons. Okay? Lok Adalat में भेजते वहाँ सेटलमेंट हो जाएगा. Order will be drawn accordingly. Already matter is settled, right? With the consent of the parties, let this matter be placed before the executive of the party. तो अभी तो आपका कोई आए नहीं थे, रिस्पोंडेंट कहाँ है? हम लोग कैसे बिना दोनों की प्रेजेंस के कैसे? आप तो ऑर्डर पास कर दिए. ऐसे कैसे आप लोग सोमवार को आप लोग से सबसे फोन पूछ के रखा गया है सर? कौन सा सीरियल नंबर? 11. At the request of the counsel for the petition, course discussed 10:30 first case. क्योंकि परसों ही तो है लोग बताने.
हमको खबर नहीं करते.
From the supplementary list, under heading 4, hearing under order 41 Rule 11 of CPC item 7, second appeal 87 of 2023.
Initially lodged in 1974. I purchased this food land, property of 32 residents from defendant number 4 to 7. Thereafter, lodged defendant number 4 to 7 again sold about 15.5 districts of land to defendant number 1 to 3 in 2006.
Defendant number?
Not sure.
Sold to defendant number?
1, 2, and 3.
In 2006.
Suit land lordship is only of 5 districts of land. It has been repeated by the plaintiffs.
Suit land is only 5?
Only 5 districts. It is repeated by the plaintiffs that is 5 districts of land out of the total 15.5 districts. That was by 2 KRs. 1 10.5 districts and 1 5 districts. This 5 districts is overlapping my 32 districts, which was purchased by me in the year 1974 itself. So that is the entire case. Both the courts lordship have come to the conclusion that since I could not bring any evidence to show that this is the overlapping plot and neither I have given any application nor I have gone for any demarcation of land, and since in 2006 when the land was being occupied by the defendants, I raised no objection and the demarcation was done, and thereafter they have constructed the suit plot, house over there. And in 2010 I raised this objection. This is the entire case. And my substantial question of law is that this question of one substantial question of law that will suffice.
Did you challenge the safety?
Not sure.
Did you challenge the safety?
No, sure, I did not challenge it because the same. It was them to show that they have purchased property which is not new.
No, that's right. But if there is a safety with respect to the same property,
Same.
same property, no? Some overlapping property.
That is the what they are saying. Not that since we have purchased, it is a separate property. I said it is my 32 districts of land. 5 districts they have captured and they have constructed the house only on those 5 districts.
Do you want to say that this 5 decimal is beyond their safety?
That's what I am submitting, that this was in my part earlier, because since we had purchased in 1974, this 32 districts was intact, but subsequently they purchased
This is in plot number?
Plot number, they are saying it is a different one. Somewhere they have said that they have no concern with the land, but still the house has been constructed. Only the issue remains on the demarcation of land. A very small issue was there. None of the courts have taken consideration of it. Even the 144 proceeding was initiated, wherein also it was observed by this SDO that the main thing is that since 144 proceeding is there, it is an entire matter of demarcation, and this court is not competent, and therefore the demarcation should have been done by the parties or by a proper suit. When this suit was brought lordship, none of the court took pain as per the CPC lordship to get the land demarcated by a survey knowing Army
Did
Commission
you
or
file any petition for demarcation?
application was not filed.
Nobody was-
I'll
When nobody files an application, why should the courts know more to go for demarcation?
that is my velocity in this case. Actually, the application was not filed. C was
There's
at
nothing
grade
in
6.
this case. There's nothing in the case. Heard the learned counsel appearing on behalf of the appellant. The counsel for the appellant has submitted that the appellant is claiming the property by virtue of a registered sale deed of the year 1974 to the extent of 32 decimal. The appellants were the plaintiffs in the court and they had purchased the property from defendant number 4 to 7. However, defendant number 4 to 7 had sold 15.5 decimal of land to defendant number 1 to 3 in 2006 and 15.5 decimal of land had 2 carries, that is 10.5 decimal and 5 decimal. Submits that the suit property is only in connection with 5 decimals of land. The learned counsel submits that the case of the plaintiff was that the 5 decimals of land purchased by defendant number 1 to 3 from defendant number 4 to 7 was overlapping with the property of the plaintiffs, which consisted of 32 decimals. The learned counsel has submitted that no steps were taken for demarcation of the land. The court did not take any steps for demarcation of the land, and the title suit was dismissed, the appeal was also dismissed. However, during the course of arguments and upon a query by this court, the learned counsel for the petitioner has submitted that none of the parties ever filed any petition seeking demarcation of land before the court. After hearing the learned counsel for the parties and this court finds that both the courts have given concurrent findings in connection with the suit wherein the plaintiff was claiming title with respect to 5 decimals of land. And admittedly, the admittedly none of the parties had filed any petition seeking demarcation of land. Both of you were having mutation.
Lost.
The records further reveal that order of mutation was passed in connection with the 32 decimals of land purchased by the plaintiffs and also with respect to 15.5 decimals of land which was purchased by defendant number 1 to 3. the defendants had also asserted through their witnesses that after purchase of the land they had constructed boundary wall and were residing over the property. थोड़ा findings हम डाल देंगे residing since 2006. This court finds that there is no substantial question of law involved in this case, which is hereby dismissed. साढ़े 12 बजे बोलेंगे
जी out of turn fixes item 5 from April 2nd April 106 of 2024.
ये 232 है कौन सा केस बोला
ये लेडीज आइटम
केस नंबर बताइए
ये 106
आप हमको 232 पकड़ा
सॉरी
लीजिए
सॉरी
अब क्या पास हो गया कोई बात नहीं इनको सुनते पास हो गया पास हो गया
item 5 हुआ item 8 second appeal 232 of 2023.
आपका केस बताइए
and also different intersuit as well as in the complaint finding is there.
The suit was decreed.
Suit was decreed in favor of plaintiff, our defendant was against him. Other judgment is there. Judgment is different on the appeal, that is and that was also dismissed against that for that.
You are the sole defendant.
Yes,
So you have lost in both the courts.
we have lost in both the courts.
So
There was land of 2.18 acres, 2.18 acres, 2.18 acres. And 3 recorded rails were there, 3 brothers.
you read the case of appeal. You read from title suit judgment or you can read it from appellate courts.
Plaintiff's case were there.
Just a minute. You read from appellate courts judgment.
Yes.
Para number 2.
These are the plaintiffs wanted before the video is that the suit ran within an area of 2.18 acres. Para number 20, village of Jharkhand, district Punjab, recorded in the name of Swami Asham, Chaudhary Asham, and Rama Asham, having equal share as a real interest. In the record of right to justice survey record, Chaudhary Asham had 1/3 share on Khata number 20, who died living behind his only son, Chakku Asham, alias Chakku Mansi, and he inherited 1/3 share in Khata number 20. Chakku Mansi, by discharge date of will dated 16/2019, transferred his remaining land of Khata number 20 situated at his Grammy official in favor of his wife, Bharmati Devi, who accepted the same and came into possession. The further condition of the plaintiff is that due to inadvertence, it is retained in the deed of will and area 0.42 to 2:2 taken piece of 0.3 in place of 0.35 is to 5/6 acres consisting of 0.8 acres in block number 75, 0.23 half share 8 acres in plot number 86, and 0.02 is to 5/6 acres in plot number 199, and
0.01 and half acres in plot number 242 of plot number 20.
ये क्या मतलब हुआ है सेंटेंस? Due to inadvertence, it is written in the deed of gift an area of 0.42 और 2/3 इसका क्या मतलब है? 0.42 2/3
The half 1/2 is the half and 2/3.
0.242 2/3 in place of 0.35 5/6. Consisting of 8 acres in plot number
75 and find 2 3 and half acres in plot number 86 and find 0.5/6 acre in plot number 191 and 0.01 and half acre in plot number 240 under खाता number 20.
इसमें कोई एरर नहीं है, बाकी खाता नंबर में सिर्फ एक ही खाता नंबर में एरर है, प्लॉट नंबर 75 में।
Yes. Position of the above line of खाता number 20 building an area 0.35 by 5/6. That normally they will be slowly in due course gifted the state land of खाता number 20 village belonging to but registered deed of gift dated 11/2001 in favor of Alopment who accepted the same and came in possession of the land in question. The plaintiff responded applied for mediation before the same, Manatu to allow the mediation application and issue plaintiff in favor of the plaintiff respondent. The defendant preferred an appeal number 2005-6 before the ACLR in the capacity of legal representative of Alopment and same was dismissed by order dated 5/7/2006 with a direction to explore the civil court for claiming back title and interest as a legal representative of the deceased non-party. But the defendant is still of final notification to legal number 7 before the additional collector Palano against the order dated 5/7/2006 in commission of the number 25/6 before the additional collector Palano and same was dismissed and also state decided to follow petition dated 17/12/2004. Asked to favor of the plaintiff and directed the parties to court of civil proceeding basically give rise to the cause of action to present the suit before the court. In the case of the defendant appellant who used the plant hearing also before the bench was that no cause of action on the rules as state law legal claim and the suit is not applicable on law as well in fact the suit is under review and the way the suit is barred by non-member of the citizen party. The plaintiff respondent has challenged the order of the CO, LRDC and AC Plano and had not been made party and therefore in his absence of the suit is bad. The suit is barred by the provision of the New Succession Act and transfer of property and of limitation also. The suit is also barred by section 34 of the Special Act and the pursuit of paper. The stolen and acquisitions. The further condition of the defendant can be is that the suit that comprised of the 5 plots of खाता number 20 and all the 3 brothers had equal share in each plot. That Raman Shah sold his entire 1/3 share of in the year 1924 by registered deed of sale number 77, which Rita Dusha, Anu Dusha and Chaudhary Dusha, the remaining 2 brothers remain in possession of the 2/3 share of county. Chaudhary Dusha died first living behind his only son, Chatu Dusha, whereas Anu Dusha died later in the year 1970, living behind his 2 daughters, Kumari and Bapesuri Devi. The Bapesuri Devi in due course of on the 6th year of the son of his sister Sudini. The defendant and the defendant was enjoying 1/3 share and the share of Anu Dusha. That Chatu Dusha in his lifetime sold 0.22 and half of plot number 75 to the Rita who came in possession and area of 0.1 by 2 to the 3 acre remaining plot 75 plot number 75. As such, Chatu Dusha sold the land below his share and possession. Chatu Dusha also sold 1.15 acre of land of plot number 86 by registered deed number 803 dated 1994 and land 654 dated 22/1992 Lalanda and Vasudev Ram further sold 0.03 acres of plot number 242 Ramlasa by registered deed of sale number 1829 dated 9/3/1977 and therefore Chatu Dusha was left with 0.32 acres of land of plot number 86 and 0.5 dispute 2 by 6 of plot number 191 and 0.01 acre of plot number 192 at the time of the death. And Chapter Dusan death with no land in plot number 75, plot number 42. The deed obtained by the plaintiff's owner from Almaty by allowing her to maintain her in her life and to perform slab after her death, but soon after execution of the deed of gift, the owner Almaty was kicked off by the plaintiff's owner, and therefore, when the plaintiff applied for mediation, the owner Almaty herself appeared before the venue authorities and opposed the mediation of petition, and mediation of this was dismissed by order dated in the speech with the power which the plaintiff preferred the petition of the ARDC. Lamus were also the owner Almaty was appeared but died during the course of agency of the bill, and the defendant are the legal heir and successor of the owner Almaty along with Mohan Pushar and grandson of Mohan Pushar. They appeared in the appeal to represent the sphere of Almaty and to safeguard their own interests. Despite this, the case was presented back to the CA by order dated Chapter the directing him to mutate the name of the plaintiff against which the defendant referred the division number 18 to 2024 to the additional collector of Palam. The division was also prepared in number 64 of 2004 to the Islam. I give the order of the Navy Code of the DC Lava State. Further case of infringement and that the deed of gift in favor of plaintiff is not valid and it has been obtained by dealing the owner must personal Almaty and the deed of gift also not decide the acceptance of the deed by the gift by the owner. The deed of gift was conditional and condition of the gift has not been fulfilled by the owner, and therefore the deed of gift is right apart from this. The owner has proposed the limitation on the violation of condition of gift, and the owner can still remove the deed of gift by excluding the cancellation date number 11650 dated 22/2001, and at least deed of gift never came into effect nor the only remaining possession of the land as alleged by the plaintiff. This matter has been papered on the following grounds of the.
So now the point is, first one is limitation. What is the finding on limitation?
Point number 1 to the line of decided. So, on the point of limitation, the case of the plaintiff is that the plaintiff is going to obtain the deed of gift in her favor from one Almaty, and on the basis of the gift, she applied for limitation and same was accepted all in her favor against gift. The defendant filed an appeal before the DC law in the capacity of the owner Almaty Devi, and same was dismissed by order dated 5/2006. The defendant was directed to appeal the court of limitation, but the defendant received the file limitation within the circumstances by which the order of petition in favor of plaintiff was satisfied by order dated 8th in favor of the Almaty Devi. The order of the AC Plan Notice is Section 4 before the court review, and by Section 4, which is dated 8th both the parties were directed to the court of limitation and the dispute related to court, and the plaintiff subsequent to the order dated passed by the AC filed the suit.
Is there any error in this finding?
Not the one thing. So, give me this class. The first one is Chatu Dusa, the dictate on the land office here.
I'll come to that later. You see, there are 4 points of determination. I am going through each point of determination. Is there any error in this point for determination number 1?
The point of determination by the date was nothing. So that has not been made an issue before the Sunday court.
Limitation was not an issue.
Limitation was not an issue.
Even if the court has to see the point of limitation,
Yes.
even if it is not an issue. You are the defendant, right? You claim that it is barred by limitation.
Yes.
Now the appellate court is considering it. Is there any error? No. Now point of determination number 2.
The exclusion of deed of gift.
Yes. In excess share, whether Chattu Dusar exceeded gift of deed of gift in excess of his share.
Yes. Okay. As per the legal statement of this deed dependent, who is the plant.
this Chatu Dusad have already not sold a land to some other persons. Not he,
Entire share.
only 0.1 have of the was in his year, and he has gifted the property to now people for 0.35
His share was how much?
His share, Chatu Dusad was there with his share of 0.15 and he has gifted 3.35 by 6.
Donor of Manmati Devi named Chhattu Dusad had 72.6 decimal of land out of 2.18 acres in his share.
Yes.
And he sold altogether 33.5 decimal of land and gifted the remaining share by Exhibit A by 4 to the extent of 35.5/6 decimal of land, which is altogether 69 decimal, which is less than his share. गलत है finding.
But this was not determined and still not trial.
भाई ट्रायल कोर्ट में कोई चीज छूट भी जाएगा तो एपेलेट कोर्ट तो सब चीज देखेगा ना. आप बोलते हैं एक्सेस बेच दिया. एक्सेस बेचने का कैलकुलेशन तो यहीं पर है. Even if something is left to be decided by the learned trial court, the appellate court is the court of fact and law both.
Yes, sir.
So point of determination number 2 में क्या error?
As per my that I have submitted, that when there is only in the company itself, it is only the Chatu Dusad has already sold the land.
So it is a finding of fact, and I am asking you what is the error in this finding of fact? Concurrent finding है. Now the point is that you are alleging that he sold in excess. So you have to show some perversity. From where do I get this?
The DNA, the report is not. The ones that is the substance. Bloody guilty. Today is more or less regarding Chatu Dusad. We have a guilty excluded by the Mamati. Mamati Mamati got a gift in land through the gift by us to Chatu Dusad. Mamati got gifted some bulk city. And will be the gift deed that has been executed by the Mamati. Whether or not there is condition to make
That is a separate point. But so far as this is concerned, this finding is there that the gift was not in excess of the share. Now the third point for determination. Whether the gift is a conditional gift. Roman 3. Correct?
Yes.
This is what you are arguing.
Yes.
Now let us see what is the finding and then we'll see.
At this date of 14 at the date of the running payment and the base limit. So far the deed of gift is concerned as conditional and concern is said to be violated. The limit will know by deciding the issue number 7. Quoted the provisions of section 126 of transfer of property, which deals with the provision of suspension of revocation of gift, as said that it can be revoked or cancelled if there is a specific terms in the deed of gift in this regard. Apart from this, it is also held that under the provision of section 126 of the transfer of property, failure to the donor to maintain the dwelling is the mere direction of a gift but not a condition. Apart from this, I'll bring to the evidence that is number 3, that Kumar Manji, who is the son of the sister of Manmati Devi, in his evidence have used that plaintiff's only served well to her mother Manmati Devi till her life, and she was pleased with the service rendered by the plaintiff's and the staff of Manmati Devi was done by Rajkumar Ram, husband of the plaintiff's and this fact has not been disputed by the defendant during the course of cross-examination, and therefore the plaintiff's has been able to prove before the court that even if there was a condition, even if there was condition in guilty, the same has been fulfilled by the court.
क्या बता? इसमें कुछ है ही नहीं. AK point for determination is a very recent judgment. Substantial question of law कैसे बनाया? Heard the learned counsel pleading on behalf of the appellant. The learned counsel for the appellant has submitted that the gift deed executed by Chattu Ram, Chattu Dusad in favor of Manmati Devi, his wife, was in excess of his share. He has also submitted that the gift deed was a conditional deed and the condition of the gift was not satisfied. And therefore, the claim of the plaintiff based on gift deed would not be decreed. This court finds that the suit was decreed and the appellate court has dismissed the appeal filed by the sole defendant, and now the sole defendant is the appellant before this court in second instance. ये पैरा 2, 3 and 4 of Appellate court statement लेंगे, पैरा 5 ठीक है? It was a specific case of the defendant that the plaintiff allowed Manmati Hoover to maintain her during her lifetime and perform her shraddh after her death, and got the gift deed from her. But the condition was not satisfied. The learned trial court framed the following issues for consideration. The findings of the learned trial court, in short, are as under. So far as the learned first appellate court is concerned, the following points were the points for determination. Paragraph 8. This court finds that the learned first appellate court has also considered the materials. Para 8 में नहीं है, para 9 में. Has also considered each of the points for determination and has held that the suit was not barred by limitation while deciding point number 1. While deciding point number 2, the learned court has recorded a clear finding that the donor of Manmati Devi, namely Chattu Tushar, at 72.6 decimal of land out of 2.18 acres in his share, and he sold altogether 33.5 decimal of land and gifted the remaining by exhibit A by 4 to the extent of 35 5 by 6 decimals of land, which is altogether 69 decimals of land, which was less than his share. And therefore, it could not be held that Chattu Tushar, the donor of Manmati Kuvar, transferred more land than his share. And the point of determination number 2 was decided against the defendant. While considering the point of determination number 3, the learned first appellate court clearly recorded that the plaintiff were able to prove that even if there was a condition in the gift deed, the same has been duly fulfilled by the plaintiff. The court also considered the deed of cancellation, that is Exhibit C, and observed that the said deed is unilateral deed, and a deed of gift once executed can be cancelled or declared null and void by the court of competent jurisdiction, and the deed of cancellation before the sub-registrar has no value in the eye of law. Ultimately, the point of determination number 3 was also decided against the defendant. So far as the non-joiner of necessity party is concerned, which was part of point of determination number 4, the learned court held that the state or the AC Palamu were not necessary parties to the suit and decided this point in favor were not necessary parties. This court finds that this court has gone through the judgments passed by the trial court as well as the learned first appellate court. And during the course of argument, the learned counsel for the appellant has not been able to point out any perversity in the matter of appreciation of evidence by the courts. There is no point or no substantial question of law involved. Accordingly, this appeal is hereby dismissed.
Item 9, second appeal 1 of 2026.
Lord, the plaintiff is the applicant before this honorable court. I am the plaintiff, I am the daughter of the deceased father-in-law under the Muslim law. Now, and the main defendant number 1, Lord, is uterine brother. एक ही माँ से हम लोग full brother and sister, Lord, are the parties in this case.
Full brother and sister.
Means uterine brother and sister. Plaintiff is the daughter and is the son. So brother
and sister through the same mother. Father is also the same.
Uterine word लिखा हुआ है.
आप ही बताइए uterine का क्या मतलब?
Uterine from one from the uterus of mother, one mother.
From one mother, not necessarily same father.
Now, under the Muslim law, Lord, the chart is given. This is governed by Hanafi school of law. And there is a chart, Lord, and predefined share for the heirs, Lord, is given there. Predefined. Now here is a suit which was filed, Lord, for seeking declaration of right title as regards her share, Lord. Now it has come in the finding of the court below. Earlier partition has not taken place. Court partition. Now when this finding is there, now the question for your Lordship's consideration is that the Appellate court and both the courts will be dismissed, saying that in the averments in the plaint, you have said that we are jointly living, whereas jointness is not conceived in Muslim law, it is in a Hindu. This is what, so concept of jointness is not there. But jointness means, that word should not be taken in that particular, should be misread in that way. The entire, the averments of the plaint and the relief sought for. Now here, Lord, but one thing I just bring to you also notice. One paragraph I would read, Lord, from the Appellate court, in which he says, Lord, that in the plaint, the plaintiff has failed to specify as to in which portion her share is there. How can I say, Lord, when already a finding is there कि earlier partition नहीं हुआ, तो हम कैसे बता देंगे कि किस portion में हमारा, Lord, I'm just because this is a contradictory statement. On one hand, you found that there is no earlier partition. तो मेरे प्लेट में वो चीज आएगा कहाँ से? I'm just placing.
Were you seeking partition? No, you were not seeking partition.
No, not partition. I'm seeking title and declaration as against my share, Lord, which is predefined.
Predefined means what? Predefined means in terms of ratio, in terms of portion.
One third,
one fourth. ऐसे तो predetermined area तो नहीं हो सकता unless there is a partition. It can be half share. But which portion of the property would constitute half share of the plaintiff, that has to be determined by the court.
No. So
right?
This is what.
So this is not a partition suit.
No. When I am seeking declaration of title, then it was the duty, Lord. I be seeing, Lord, my relief sought for. उसमें प्रेयर ये भी है सी में, Lord, declaration upon such declaration, a preliminary decree for partition of the suit property will be passed. मैंने हमको division करके आप बता दीजिए. And this is what, Lord, Appellate Court also has dealt with the observations of the Supreme Court. Supreme Court का भी एक portion हम पढ़ के सुनाना चाहेंगे Appellate Court से. Appellate Court को हम quote कर रहे हैं page 38 of the running page, Lord. Para 20 है. If your Lordship permit, Lord, just place, Lord, para 20. The shares of heirs under Mohammedan law are definite and known before actual partition. Therefore, all partition of property belonging to a deceased Muslim, there is a division by metes and bounds. So this is what for My belief is, so now what the Appellate Court said not in the last paragraph, page 39, what it says not, in the light of law settled by our court in the judgments aforementioned and the custom prevails in the district, when I see the pleading and evidence of plaintiff and find.
Where is the finding that there has been no partition?
No.
Because you claimed that there was partition.
No, this finding is para 18, page 21, Lord of the trial court.
Page
21, Lord.
21 of trial court.
My Lord.
Yes.
Issue number 3, page 65 running है. Page 65 is running page.
Finding खाली दिखाइए that there was
Finding खाली दिखा रहे हैं. Issue number 3 है whether earlier partition. और उस पर आ गया this issue number 3 last line है decided in favor of the plaintiff and against the contesting defendant. हम लोग का उसमें argument था कि earlier partition कभी नहीं हुआ and this is what not the finding.
नहीं आपका argument था कि earlier partition हुआ है.
हम लोग के फेवर में ये इशू नंबर 3 डिसाइड हुआ और प्लेट में देख
Anyways, आपका suggested substantial question of law क्या है?
Substantial question of law is that the appellate court both the courts, since this finding of no earlier partition was not set aside by the appellate court, so that finding is there by both the courts. So when both the courts held that there was no earlier partition, then the suit having been dismissed on the plea, on the ground that the plaintiff failed in the plaint as well as in the evidence to show as to in which portions, what are the portions of Schedule A and B belong to her, will fall in her share. Because both these findings are contradictory to each other. Once you hold earlier partition, तो अब आप हमसे मांग रहे हैं कि जो पेज 26 में हम दिखाएगा आपने कोर्ट का मिरर, the last paragraph of the article, page 39. It says that when I see the pleadings and evidence of the plaintiff and find that nowhere, neither in oral evidence nor in documentary.
Page number?
Page number 39, not running.
Yes.
In the light of law settled by honorable courts in the judgments of aforementioned and custom prevails in the ensuing community, when I see the pleadings and evidence of the plaintiff and find that nowhere, neither in oral evidence nor in documentary.
ये B से चलेगा आपका?
Pardon?
Substantial question of law number B से चलेगा? B.
No allotment of trade in law.
इससे चलेगा?
चल जाएगा
या फिर इससे F से चलेगा? B और F में से देख लीजिए कौन सा आपको चूज करना
B और
है। F
F
B कर देते हैं, B ठीक है, ठीक है, B कर देते हैं सर, that should be sufficient. Heard the learned counsel explaining on behalf of the appellant. The learned counsel for the appellant submits that there is a finding of the court that there has been no partition with respect to the suit property. However, in spite of that, no portion has been allocated to the appellant, who was the plaintiff in the case and was also seeking partition. After hearing the learned counsel for the appellant, this appeal is directed to be admitted for final hearing on the following substantial question of law. B, page number 7. Issue notice to the respondents for which requisites under speed post be filed within 1 month. बहुत सारे respondents हैं. Call for the records from the concerned court. Post this case on 10th of June.
हियरिंग में केस आ जाना नहीं हो सकता उसमें स्टे कल
अभी तो कॉल आउट किए थे आप. कोई
कॉल
hearing
आउट
नहीं
हुआ
हुआ.
था द अदर साइड वाज नॉट देयर
नहीं कॉल आउट किए थे आप, नहीं किए अभी.
नहीं हम थे ना
नहीं
हम तो बहस किए थे मैटर नहीं
कहाँ है आपका?
हमें तो कल पर I was there, my lord, all my lord. And this matter was heard at length by your lordship. 4-5 pages order as last order. सारे एविडेंस को डिस्कस करते हुए your lordship had framed one new substantial question. By the last order, we got no Bharat purchase. Misleading, माने on admission और मुझे को याद पता नहीं.
याद है.
Evidence are quoted करके substantial question of law बनाता है.
चलिए बहस करिए.
That's the problem. My God. Lord,
कौन सा substantial question of law है ये बताइए.
last order no Bharat purchase.
9/12/25. This is one substantial question.
27 March 2025 two substantial questions.
27 March
2025.
two questions were framed, and on 9/12/25, one question was raised. Altogether, 3 substantial questions.
Lord, the genealogy has been introduced by a stranger. Admittedly, they admit in we are the defendants, Lord. Now the plaintiff introduces a stranger, introduces himself in the genealogy of the petitioner, and he says कि हमारे जो नाना थे बिरसी धामणी लॉर्ड is the appellant before this honorable court and is defendant. बहुत शॉर्ट में हम हुजूर प्लेस करना चाहेंगे जिससे हुजूर रिकॉल कर लें। हुजूर को बहुत डिटेल में सुना हुआ भी है और ऑर्डर किया हुआ। Lord, now what is being introduced and disputed, Lord, which was for consideration. अब वो इंट्रोड्यूस कर रहे हैं जेनेलॉजी में, हम खाली एक पन्ना जेनेलॉजी का एक सामने ला देते हैं, उसको देखते हैं, उसी से बात सारी बन जाती है कि जेनेलॉजी एट पेज 13 देखा जाए, उसी से सारी बात मैंने proposition value of substantial portion of law in place. पेज 13 में, रनिंग पेज 13 में और the appellate court judgment.
हमको याद है, हमारा सुना हुआ मैटर है।
इसमें दो सुप्रा मिलॉर्ड इज माय नाना, डिफेंडेंट के नाना हैं सुप्रा मिलॉर्ड, और सुप्रा में वो कहते हैं कि नहीं दो भाई उसके और थे जो ठूठा और हबलू। Now this is being introduced and which is being disputed. Now genealogy को जब disputed होगा तो बहुत section 102 blood evidence act, the Supreme Court says that it's very should be taken very seriously and has to be proved very strictly because some stranger is going. Now here now I'm just summing up. Now
summing up अभी तो शुरू किया। अच्छा ठीक, आज तो नहीं हो पाएगा कम।
ठीक है तुम लौटे।
We'll continue it on Monday at 1 o'clock.
जी हाँ,
आधा घंटा 2 दिन सुनेंगे तो हो जाएगा।
हाँ जी हाँ, और इसको तब तक स्टे माय लॉर्ड। सब अदर साइड स्ट्रेंजर सब है उसको।
नोट्स बनाइए सर, बिना नोट्स बनाइए। हाँ? नोट्स बनाइए।
बना देंगे, नोट्स नहीं बना। माय
The learned counsel for the appellant has submitted that the appellants were the defendants in the court and substantial question of law has been framed by the order dated 27/3/2025 and further and additional substantial question of law has been framed by the order dated 9/12/2025.
law.
The hearing of the case has commenced. Since the court time is over, post this case for further hearing on Monday. The interim order passed Monday at 12:30 नहीं होगा, नहीं होगा नहीं।
Facts are not too much because clumsy. Only we have to show there is no that we could not prove the generalized, and we have to show that we
at
have
12 at 12:30 at 12:30 on Monday.
Learned senior
Till Monday the interim order is extended. Till Monday the interim order passed earlier is extended. नोट्स बनाएंगे, आप भी बनाएंगे।
ठीक, नोट्स एक हम भी बना।
आप बनाएंगे। ज़्यादा है नहीं इसमें।
हाँ, ज़्यादा उनका भी बहुत कुछ लिखा है।